Good evening to everyone. I think we still have a few people coming in, including Karine, so we'll wait for Karine to be sitting. Well, on behalf of the Academy and for the students, thanks to all of you for being here tonight. On behalf of the Bureau, but Diego, our president, is not here. Karine, who's just here, Marina, and myself, we're really happy and delighted to welcome all of you to the second Emmanuel Gaillard Debate. I will start with an immense gratitude, and I will pass the microphone to Yves for GBS Dispute for organizing, setting up this beautiful venue, and particularly with Yves, whom we've worked a lot these past few weeks and months to organize this debate. So if you want to say a few words, then I will pick up afterwards. Thank you.
Merci, Julien. Merci beaucoup, Julien. Good evening, everyone. It is my immense pleasure on behalf of Gaillard, Banifatemi, Shelbaya Disputes. I hate GBS.
It's your website.
It's part of the logo, but the true logo is Gaillard because I don't want us to forget Gaillard. Gaillard is really the important part of the Gaillard, Banifatemi, Shelbaya Disputes. And that's why actually we're doing this. Last year, Professor Cohen and Karine and Christophe Seraglini asked us to organize an event, a yearly event in honor of Professor Gaillard. And we thought that the best event would be a debate because Professor Gaillard was the finest debater ever. So this will be a true debate, and we have two reasons to rejoice today because we have two of the finest thinkers here, Professor Andrea Bjorklund and Mohamed Shelbaya, who will discuss, that's the second reason to rejoice, a very topical and complex question of international arbitration, which actually was close to Professor Gaillard's heart because he and you, those of you who know his thought and his thinking process, he was very much focused on transnational rules, and he was troubled, and I'm not anticipating the debate, he was troubled by the fact that reflective loss, and I'm now starting almost on the topic of today, is not recognized in domestic laws. How is it that it is recognized in international arbitration? So that was part of what he really wanted to think about, and analyze, examine, and write about. So he did not have the time to write about it, sadly, but the subject has been picked up by others, including by Mohamed, who's written about it. And so we will have a very fine debate today, and I'm really, really proud to have you here with us. And there will be a cocktail. Those who are not staying for the cocktail, you need to leave before 8. Otherwise, we'll see you upstairs in a moment. Thank you very much. Thanks for being here.
Thank you very much. So I will continue with this short introduction by saying also, and Yas knows it, that it is important and a pleasure for Marina and myself to be moderating the Emmanuel Gaillard Debate because actually both of us started our career with Emmanuel and with Yas, so it's also a pleasure and really emotional for us. So my first task is to do what we always say is that they don't need an introduction, but still to introduce Andrea and Mohamed to the very few, and I imagine not so many of you that don't know them. So first, Andrea, so Professor Andrea Bjorklund, in a few words. So she's a full professor and the Yves Fortier Chair in International Arbitration and International Commercial Law at McGill University, Faculty of Law, my alma mater. But I will not take sides tonight, even though I'm on this side. Andrea was also the inaugural ICSID Scholar in Residence in 2014, and she sits on the panel of the AAA's International Center for Dispute Resolution, as well as on the roster of the NAFTA Chapter 19 arbitrators. She also has joined the ICSID panel of arbitrators. Prior to joining McGill, Andrea taught at the University of California Davis School of Law, and before being a full-time professor, Andrea was an attorney advisor on the NAFTA arbitration team in the Office of the Legal Advisors of the US Department of State. First debater. Second debater, Mohamed Shelbaya. Mohamed is Paris-based attorney and founding partner of Gaillard Banifatemi Shelbaya Disputes, and is recognized as a leading figure in arbitration with a particular focus on arbitrations in the oil and gas sector. Prior to founding Gaillard Banifatemi Shelbaya Disputes, he was also a partner at Sherman & Sterling, where he practiced for more than 12 years. He has represented companies, states, and state-owned entities in more than 70 investment treaty and commercial matters. he also acts as president, arbitrator, and co-arbitrators in many arbitration disputes. Finally, he also serves as a member of the LCIA court and as a president of the LCIA's Arab Users Council. Two important pieces of information before I pass the floor to Marina, who will introduce the debate. First, Andrea and Mohamed have promised a fierce debate, proposing opposing views on the topic at hand to ensure a proper discussion between them and possibly a discussion with the audience at the end. Second, and it's a necessary caveat for this debate, Andrea and Mohamed have also been assigned a position that do not necessarily reflect exactly their views and personal views on their position at all times. So the next hour and a half is only for the pleasure of lively discussion and debate. Marina, just if you want to introduce.
Good evening. So it's a pleasure to be here with you tonight. So I'm going to make a very brief and high-level introduction on the topic of shareholder claims, also to the attention of our student here. So as we all know, foreign investors very often invest abroad by acquiring shares in local companies that own local projects. And very often too, they acquire only a minority share because in most of the corporate domestic law, there are restrictions on foreign equity. So foreign shareholders cannot acquire a controlling interest in local companies. And what it happens that a host state engages in acts that amount to indirect expropriation, for instance. Very often the foreign shareholder is left with no satisfactory remedy in domestic corporate law. So while in most domestic corporate law, you have a possibility to engage in what they call direct loss claims. Reflective loss claims are not accepted in domestic laws. And what are we talking about? A direct loss claim is the claim for direct injury, to obtain compensation for direct injury caused to the shareholders' rights. It will be an injury to the voting rights, it will be an injury to the dividend rights, it will be an injury to the right to obtain a share in the company in case of dissolution. So this is very restrictive. Reflective loss is the possibility to obtain compensation for the shareholder for the indirect loss caused to the company which he possesses. In other terms, it will be the loss which consists in the diminution of the value of the shares of the local company. And this is different from what we call a derivative action or a preventive action, which allows the shareholders to act on to sue for the damage suffered by the company on behalf of the company. There, the cause of action belongs to the company, but the action is put forward by the shareholder. So we have those different notions that will be developed and presented in detail by the panelists. There are a lot of nuances, but just so the things that we have to keep in mind now is that in most corporate domestic law, you don't have reflective loss action. This is a very specific feature of investor-state dispute settlement. Why is that? Because most of the BITs consider that shares constitute investment that can be afforded treaty protection. So the question will be, are those reflective loss actions good things policy-wise? And the supporters of the theory will tell you, well, it is a very good thing because it offers a guarantee of compensation to the investors that will not be available otherwise. The opponent of the theories will tell you, well, granting an action to different actors at the corporate chain against the same state for similar acts is not something good. Because first, it can enhance treaty forum shopping. Second, it can favor the risk of multiple proceedings with conflicting decision with the risk of double recovery. And finally, another very recurrent criticism is that reflective loss actions would somehow distort the principles of corporate law. For instance, by taking away the fund from the company in favor of the shareholders, instead of distributing them to the creditors of the company in the context of insolvency. So those are just a few of the issues, and our panelists will discuss the pros and cons and the risk and benefit of those actions. So, and I finish here.
Yeah, so now we can start the debate. So Andrea, in a few minutes, could you introduce, in your view, the topic, and then Mohamed will do the same with his own prism.
Thank you very much. Thank you, Julian and Marina and Yaz. It's really an honor to be here with you tonight, and particularly to take part in this debate named after Emmanuel, whom I admired tremendously and who was very encouraging to me when I was a young academic. It is also a treat, albeit rather a daunting one, to be on stage with so formidable an advocate as Mohamed Shelbaya. I hope our conversation will prove enlightening to those of you in the audience. I've learned a lot while preparing for tonight. As most of you know, criticisms of investor-state dispute settlement are numerous and often a little bit imprecise. We thus thought it would be useful to start out by specifying exactly what we are and what we're not talking about. So we hear a lot of complaints about shareholder claims, and reforming shareholder claims is one of the topics that is being addressed, albeit slowly, by UNCITRAL's Working Group 3. I'm going to try to convince you that there is nothing wrong with shareholder claims, that existing principles such as abuse of process cannot fix, and that there are, in fact, many good reasons to permit shareholder claims, including the need to hold governments accountable for their wrongful acts, to prevent them from being unjustly enriched, and to ensure that those who suffer loss can recover. So our overall topic is shareholder claims, which is not particularly specific, since many investments consist of shareholdings, which is, of course, one of the reasons that shares are nearly always in the illustrative list of investments that we see in most investment treaties. Indeed, as I will argue in more detail in a few minutes, states had excellent reasons for including shares as one of the investments covered by investment treaties, and for permitting both direct claims, that is to say, claims by the first shareholder across the border, and even indirect claims by shareholders who hold their investments through other companies outside the host state. Sometimes, as Marina mentioned, permitting claims by minority shareholders is essential because the host state requires that any business done in its territory be done via a joint venture that is a majority-owned local company, that is majority-owned by a local entity. Thus, the only way for a foreign investor to do business is by way of holding shares in a local company, and the only way a foreign investor can recover is if minority shareholders have the right to bring claims in investment law. Shareholders' claims can be divided into subsets and are frequently described in various ways. So one is claims for direct loss, another is claims for reflective loss, and a third is derivative claims. One also hears complaints about minority shareholders being able to submit claims. While this is often a reference to claims for reflective loss, even if a minority shareholder might be submitting a claim for direct loss, but it's often used in a pejorative way, even if it's not very precise. And certainly in some instances, a minority shareholder could even be a controlling shareholder and thus entitled to act on behalf of a corporate entity, depending on the share structure. So a shareholder's claim for direct loss would be for the loss that they experience themselves as a result of their investment that is independent of, or at the very least separate from, damage to the company. The expropriation of their shares would be a claim for direct loss, or the expropriation of their dividend checks. The problem is that this might apply in only a very narrow set of circumstances. Hence, in my view, the reason that investment treaties and investment tribunals have taken a more expansive approach to the types of claims permitted, including maybe the heart of the matter, the shareholder claim for reflective loss. So a claim for reflective loss is the claim that damage to the corporation caused harm to the shareholder as well, or, if you will, is reflected back to the shareholder in terms of a diminution in shareholder value. If, for example, a concession contract owned by a corporation is canceled, and that cancellation has a negative effect on the valuation of a company, then the company experiences a loss. That loss is reflected in the shareholders' value because the value of those shareholdings would lessen. Shareholders' claims for reflective loss are not usually permitted in domestic legal systems, although there are some circumstances in which shareholders are allowed to bring a derivative action to try to cause the company to act in a particular way. This is usually when there is some kind of fraud or misfeasance by the board of directors. Shareholders can thus seek to force the board to act in a way that is in the best interest of all shareholders. A derivative action in customary international law is not usually permitted either. The corporation must either act for itself or not at all, and its shareholders are not supposed to act for it. So in international law, though, and in investment treaty law, a derivative claim is the idea that the shareholder or shareholders actually act in lieu of the corporation itself, as distinguished from the domestic law instance where the shareholders bring a derivative action to force the directors to do something the shareholders want the directors to do. Sometimes this is in international law, we sometimes see this to overcome nationality problems. Sometimes it's to overcome management problems or problems with host state interference with a local company. In any case, it is essential for the protection of international investments and the establishment of an environment favorable to international investment to permit those claims.
Mohamed, do you want to introduce also your position?
Yes, sorry, yeah. I think the good part is that we don't disagree on the kind of claims that are out there and the kind of losses that are out there. But I think a good starting place is what is a claim. Claim would normally include a component which is a legal duty owed to the claim holder that has been allegedly breached, which has caused a loss, if it's a claim for compensation, to that claim holder. With that in mind, one draws in domestic law, in any domestic law, in international law, in customary international law, and now in investment arbitration, three typology of claims. Direct claims for compensation, so that's the claim in which, I think we agree, a shareholder, if it's applied to a shareholder, the shareholder would claim the only things that they own in a company, which is the shares, the right to participate in meetings, and declare dividends that have been declared in the company, and ultimately what they receive at the end of the company upon post-liquidation, which is share of the assets that then remain. That's it. Everything else is the company's. Then, reflective loss claims, that's here the legal duty is to the shareholder still, but the loss that the shareholder is claiming is no longer his directly, it's a loss that only arises to his cash as a result of a loss that actually was inflicted upon the company itself. So that's the diminution of the value of the shares or the diminution of dividends. Here, the primary harm is not that of the shareholder, it's that of the actual company. And the shareholder only sort of gets reflected upon. And by the way, the shareholders and many others. Reflective loss is just a general concept, right? Here, it's applied to shareholding in the sense that one loss has led to another, but it's not the primary loss. So these claims are typically barred in almost every other system of law outside of investment arbitration, be it international or domestic. Investment arbitration case law has decided that mostly it is permitted. And I'll take a little bit of here I think we start deferring, which is I do not think that's something in any BIT. That's something that tribunals have read into BITs, but that's not something in a BIT. Saying that because a BIT treats a share as an investment, and that therefore that means that reflective loss is allowed, is sort of a non sequitur, since domestic laws treat shares as property, but reflective loss are not allowed. So recognizing the legal title and interest of a person into a share does not equate automatically allowing them to recover reflective loss. That's something that has to be in its own merit regulated and provided for. So, and it confuses, and it's actually, Professor Bjorklund mentioned Barcelona traction. That sort of one paragraph there is quite illustrative. It says, this kind of logic, the logic that says, because I own a share in a company, a loss by the company impacts me financially, and therefore I have a legal claim, confuses economic interest as a concept with legal right. Claim only arises from legal rights, not mere economic interests. So that's sort of but that's reflective loss in any event, whether or not it is provided and whether or not it should be. And then finally, derivative claims, as Professor Bjorklund has said, equally are recognized in domestic law under certain exceptions, and in investment treaties, some of them at least, typically North American, but more and more others, whereas you essentially here, the cause of action is the companies and the shareholders. There has to be sort of typically at least in a derivative claim in a domestic concept, the company had to have a cause of action itself, and you allow the shareholder to bring the company's cause of action on its own behalf because of some situations, including, for example, negligence by the managers or similar situations. So the debate is sort of, the parameters of it are sort of set, but to illustrate it a bit more so that we all have sort of an idea in mind what we're talking about. Let's take an example, and I'll keep going back to that example sort of throughout the evening. Let's take an example of an SPV that gets incorporated in any company, any country, host state X, right? And that SPV enters into a concession agreement, again, as is typical, with the host state, providing for production of oil, for example. And one of the terms of the contract is that within 5 years, you have to produce oil or you get terminated. 5 years, 4 months later, no oil production happens, the company terminates. The host state terminates. The contract provides for English law and ICC arbitration. So this is sort of the universe we have. Now behind that contract, you have a Canadian national that owns 10% of the company. You have a 90% Australian company that owns 90% the SPV. Above it, you have a Dutch company owning it 100%, and above it, you have a UK national owning the majority 100%. Now, a direct claim would be a claim by the SPV against the host state under the contract. A derivative claim would be a claim by any of these controlling shareholders, so the UK national, the Dutch company, the Australian company, on behalf of the company, or the minority, if we allow minority shareholders to bring a derivative claim. Nothing inherently precludes that. And then a reflective loss claim is a claim by all of these people saying, the company has lost 100% of cash, I own 90% of the company, indirectly, give me $90. That's essentially the bulk of what we will be disagreeing about. With that, I leave it here.
Okay. Thank you for setting the tone. So now, Andrea, what is the need, really, for claims by shareholders for reflective losses? And do you see any issues, notwithstanding your position on this, or no issues?
Well, thank you, Julien. And well, first, I disagree about the appropriate way to interpret treaties. I think this was a deliberate and justifiable policy choice on the part of states. I think it is lex specialis deviating from customary international law. I think it's a deliberate decision to depart from Barcelona traction, about which I'll talk more in a moment. I think this is designed to give expansive protection for investors, regardless of the way they choose to structure their investments. We've already talked about the local law requirements that sometimes place limits on what foreign investors can do. We all know that there are tax reasons, the famous Dutch tax sandwich, or whatever it's called, that causes, that encourages many companies to incorporate themselves in the Netherlands. We know that there are intellectual property reasons. I was just in Ireland where we were making jokes about, the stacks of of Google patents and code in the vaults of the Bank of Ireland. So there can be multiple reasons for companies to structure their investments in different ways, and their states have chosen to accord expansive protection to those investments. Nationality planning is not abusive if it's done in advance. One could even make the argument that corporations management has a fiduciary duty in order to engage in nationality planning. That is, again, in order to take advantage of the protections accorded by investment treaties, in the same way that we look at, in English, we make this joke, I don't know if you do it in French as well, but there's something called tax avoidance, which is perfectly lawful and proper, and there's tax evasion, which is really not lawful or proper, and you go to jail for that. But tax avoidance is good and is practiced by nearly everyone. Tax evasion is bad and is still practiced by people, but we hope that they go to jail when they do so. But these are some of the reasons that the definition of investor and the related definition of investment are expansive, and they indicate the intention of the treaty drafters that investment be construed accordingly broadly. Investors have a great deal of leeway in how they structure their investments, whether that be through direct or indirect ownership, even if that is through an enterprise in a state that is not a party to the investment treaty. And I think this breadth of language is consistent with the object and purpose of investment treaties. Most of them refer to the protection and the promotion of investments. So ensuring that investors have the protection of the treaty while giving them the flexibility in the way they structure their investments, including by giving them the opportunity to invest via third countries, is more likely to promote foreign investment and encourage greater monetary flows of capital and the like. The protection of majority and minority investors is key in the international law system we have, which is still a Westphalian system with investment treaties between different states as a manifestation of that fact. Mr. Shelbaya talked about the duty that host states owe to the claim holder, and suggested that oftentimes host states don't or should not properly be construed as owing a duty to a minority investor. But I disagree with that, because the duties that are owed by the state are owed not just to the investor, but to the state that has negotiated a treaty on behalf of that investor. And if those states have chosen to encompass small investors, minority investors, less than controlling investors, shareholders in their treaties, then I think that choice should be honored. We also see that it's important that both direct and indirect claims be covered. Certainly the investor first over the border can submit a claim, but also the investor who holds shares indirectly needs to be able to submit claims to prevent a potential mismatch between beneficial interests and nationality, and thus a mismatch between who has the incentive to file claims and who does not. Sometimes you can have a potential for a change in circumstances throughout the pendency of a claim. I'm reminded of the Lowen case, where you had two entities submitting a claim against the United States. One was Raymond Lowen, the founder and patriarch of the Lowen Group, Inc., and the other was the Lowen Group, Inc. They both submitted claims against the United States. And during the pendency of the proceeding, Mr. Lowen lost control of the Lowen Group, Inc., but nonetheless maintained the claim on his own behalf. He alleged that the reason he lost control of the Lowen Group, Inc. was because of the actions of the United States. While that claim was not in and of itself ultimately accepted, it seems to me desirable that he be allowed to make it if he wants to. Speaking about something a little bit more recent and closer to home, you can have a change in government policy. The European Union for example, has done something of an about-face on its investment policy and certainly on intra-EU investment protections. Thus, Jersey-based companies suddenly look much different from the perspective of investment protection than they did not very long ago, when perhaps you would have argued that was not necessary, yet suddenly perhaps it was necessary that you incorporate your subsidiary in Jersey in order to take advantage of the still extant UK treaties with certain European Union member states. Turning to the Barcelona traction issue, you all presumably know the famous holding in Barcelona traction. In that case, Belgium sought to assert diplomatic protection on behalf of Belgian shareholders in the Barcelona Traction Light and Power Company, based in Spain. And by the way, if you're fascinated by this case, I just want a side recommendation. There is a wonderful New Yorker article that covers like the factual background of the case, and I highly encourage you to seek it out. But in that case, the International Court of Justice declined jurisdiction because the company itself was Canadian. Thus, only Canada could espouse the claim on behalf of the Barcelona Traction Company. Yet because the ultimate beneficial ownership of the company was Belgian, Canada had no particular interest in doing so. Barcelona Traction is, in a sense, a derivative case, which we're going to talk about a little bit more a little bit later. But it shows also how there can be a lack of congruence of interest between an ultimate beneficial owner and the state of origin, and of the state that has made the effort to negotiate an investment treaty to protect its investors. Now, you've probably learned already that there are many investment treaties out there. There are some 2,800 investment treaties in force. But if you do your mathematics properly, it turns out that you could have as many as 11,000 investment treaties if you do all of the combinations of states in the world. We are far from that. 2,800 is far short of 11,000, so it seems understandable and perhaps even desirable that investors seek the protection of whatever protection they can get, and that states want to protect their investors in as many ways as possible. But sometimes there can be, as the Barcelona Traction case shows, there can be a lack of identity of interest between certain companies and the states in which they are incorporated. So this is another reason I think of this as a lacuna of interest, or a lack of congruence of interest. That is another reason that investment treaties have adopted an expansive view of the definition of investment and have deliberately permitted indirect claims as well as direct claims. The drafters of the treaties, I think, were deliberately trying to overcome this problem that occurs when one entity lacks the will or incentive to protect its investors. And this is an increasing problem and an increasingly difficult problem. Multinational enterprises are increasingly diffuse, so it is harder and harder to say where is the appropriate home of the investor. I think about mergers. Royal Dutch Shell, is that Dutch or British? Budweiser, I apologize if there's anybody from the Czech Republic in the room. But Budweiser from the United States is now AB AmBev. Is that a Dutch or American company? Expansion and relocation. When I was your age, I would have thought Philip Morris was an American company based in Virginia, and it turns out it's now a Swiss multinational enterprise. Would Switzerland espouse a claim on behalf of Philip Morris? Perhaps. Would the United States? Maybe no longer. All subject to a great deal of change, and also, but illustrations of why it's important that investment treaties be read broadly and flexibly. So I think there are several possibilities, several instances in which you can see that states have an incentive to have expansive coverage of investments, and why investors have obviously the incentive to take advantage of those protections. That could include when there is no investment treaty between the majority or controlling shareholder and the host state, when there's no investment treaty between other important investors and the host state, or when there's an effective expropriation or takeover of the investment itself, the locally owned enterprise, and thus no way for it to make a claim, and perhaps no incentive for it to make a claim against a government to whom it is beholden. I note also that ironically, the increased use of denial of benefits clauses might take out the possibility for interim investors to make claims, thus making it even more important that an indirect investor be able to submit a claim. The governance aspect of investment law, I think, is underappreciated. States, remember, only lose if they have violated a treaty, if they have committed a breach of fair and equitable treatment, if they have violated the national treatment or most favored nation treatment provisions, if they've engaged in performance requirements in a treaty that forbids performance requirements, or when they have engaged in an expropriation. So investment law is not a license to hold the state responsible for any loss. It's not an insurance policy. But when a covered investor presents a claim on its own behalf, it does have to show that it has suffered loss or damage by reason of the measure that is alleged to be a breach of that agreement. Demonstrating that loss or damage and the requisite causal nexus is an essential requirement for the investor to prevail on its claim. But whether there has been a breach, whether that breach has caused damage to the investor, and how much damage is occurred are factual matters that the investor has to prove in order to prevail on the merits of its case. But this is an essential part of international law. It's similar, we see similar protections in many domestic constitutional law regimes, that a state be required to justify its behavior. We see this in human rights law as well. And we also see this as a way to protect against uncompensated takings or unjust enrichment when a state acts in its own interest to the detriment of a foreign investor.
Thank you, Andrea. Mohamed, your take on reflective losses and shareholders' claims?
Yes, thank you, Julian. And thank you, Julian, literally, to you and to Marina and to the Academy. It's a great privilege to be doing this debate, not just for its namesake, for whom I obviously have a lot of affection, but also for having the honor to share it with someone as distinguished as Professor Bjorklund, whom, to simplify, I'll be calling Andrea with her permission from now. Yeah, do it anyway. I think the first point to start with is that no one is suggesting shares not be protected, and therefore no one is suggesting shareholders not be protected. Minority shareholders need to be protected, of course. Majority shareholders need to be protected, of course. What we're disagreeing with is whether protecting the share of a shareholder, be it minority or majority, in that respect, I make absolutely no distinction. Do you protect literally what 200 years of case law across different jurisdictions have understood it to mean, which means actually the share, or do you also protect the assets of the company as part of protecting that? That's the question we are debating. Now, investment arbitration has mainly, case law, has mainly treated it as the latter. Protecting a share is protecting the assets of the company in which you hold a share, in a way or another. My submission is that it's incorrect as a matter of treaty reading, but that aside, that it is wrong as a matter of policy. Now, why that's the case? Well, I'll give you 7 reasons. Let's just dwindle through them a little bit. The first one is that simply we are reinventing the wheel with absolutely no reason. You have every single domestic law of which I'm aware. If the English and the French agree on something, that's already quite something. But when you have the Germans, the Americans, the Australians, the Canadians, the Egyptians, I don't know who else, plus customary international law agree on something, maybe everybody's wrong, and maybe they have been for the past 200 years, but you better have a good reason why you're different. Theories of exceptionalism tend to always be regressive, not the opposite. Now, there are a couple of reasons that are advanced, and we'll get to them. But first, let's see the reasons that were always made it so that when you protect a share, it doesn't mean you protect the assets of the company. One of it is just the very nature of a separate legal personality. We, as a society, 200 years ago in the 19th century, invented a fiction, separate legal personality. We did it because we structured an economy in a way that required it. We needed people to take risks. In order to let them to take risks, we needed to limit their liability. In order to let them limit their liability, we said, you don't actually own the things that you economically own. So I have this table, I want to invest this table, but I don't want the risk of debts that may come in relation to this table. I put a company between myself and this table, and that's sort of the Faustian bargain. The bargain is, I'm giving you, they're no longer my assets, even if economically they're mine, because the cash that bought it comes from me. But I don't get its risks. The problem with reflective loss is that the shareholder gets to remain free of the debts of the company, but they get to claim the benefit of the assets of that company. In a sort of famous US decision from the 70s that was best put, and I quote it because it's just so apt and it remains topical. The investors are asking us to disregard the SPV's corporate form. Although the plaintiff want us to allow them to recover for injuries mediated through the SPV, they most assuredly do not want us to hold them liable for its debts. They seek the best of both worlds, limited liability for debts incurred in the corporate name and direct compensation for its losses. That cushy position is not one that the law affords. It's not one that any law affords, until investment case law came along and it started to afford it. Now, maybe there's something that's specific. We'll see. We'll go down the list. Another thing that it does is that it disrupts also another fundamental part of how companies work. It's not just conceptual. Company, part of being a shareholder in a company is not running that company. Companies are run by their corporate organs for a reason. But if you have a reflective loss claim, and the example that Andrea gave is pretty good, if I'm the person that used to control a company, but I no longer control it, well, the corporate organs of the company need to be able to settle a claim if they see it fit, if they see it in the best interest of the company, and they have all sort of fiduciary duties to do so. If then a shareholder can have a veto over those ability to settle the claim, therefore a veto over how the company is run, and that shareholder could even be minority, because remember, reflective loss claims can be minority, then we're just altering the very basics of corporate law. We're altering the basics of companies, and in so doing, we're altering the basis of something that has guided Western economies for the past 200 years. The next step is you're also prejudicing, and Andrea alluded to that, but I don't see a solution, the rights of other shareholders and creditors. Part of the bargain is that I'm going to give you this fiction. I mean, there's a famous definition of a corporation from a satirical book that says, corporation, noun, an ingenious device for obtaining individual profit without individual responsibility. But that's okay, and you do that because you want them to take risks, but then they do not get the ownership of the assets, which means first money in, last money out. As a shareholder, you've put the first money in, but at the end, if things go bad, well, you're the last money out. Everybody else has to be paid before you. Creditors, banks, employees, what have you. When you get a reflective loss claim, how do you deal with that? I'm the billionaire owner of that company that I no longer control. That company has hundreds of employees, thousands probably, and have hundreds of creditors. Now I have money, I'm quick on my feet, I'm first to claim, I'm first to collect. There's no longer any money left for the company to give to its creditors. Investment arbitration offers no answer to that. And again, for no reason. Now, the second reason why this doesn't work is because of the very nature of property rights. Property rights are meant to be an exclusive relationship between an asset and a person or a group of people. And when there are a group of them, it gets to be specifically regulated as to how you relate. Now, the problem with how investment treaties have been construed and sometimes applied is that it creates two custodians for the same asset. There is the owner of the asset, and then there is somebody who has a right to claim on behalf of the asset. Now, again, in domestic law, we wouldn't allow that. If you have even if you have co-owners of a single asset, normally, say, for example, if multiple people, I don't know, let's take English procedural rules as an example. Under the civil procedure rules in England, if you have 3 people that own a remedy together, the 3 of them have to be party to the proceedings. In our case, we've created a system in which you have 2 custodians for the same asset and no way to organize the relationship between the 2. We've just left it to chance, left it to whoever races first. An old 1909 writer that described this in relationship to trusts, because you still have the same sort of idea of a beneficial owner and a legal owner, is that if you could treat the beneficial owner as an actual owner, you're creating total anarchy. And I think that's what we've done. Now, the next point, and here, if we can go to the next slide, is knowability of norms. Now, if we are to take investment arbitration seriously as a legal system that is meant to develop, well, the essence of a rule of law is that it's there to guide conduct. So if we are serious about actually treating treaties as norms that are there to guide the conduct of states, not just as something to use in the context of litigation to pay compensation or not, then they need to be knowable. That's sort of basic from sort of going all the way back to Blackstone in going through, in fact, actually, it's Roman law even. So, I mean, it has to be knowable, but knowable doesn't mean that knowing only that the law exists, that the norm exists, or its content. It's also knowing what set of facts it applies to. So the trigger is very important. And if you have a norm, a legal norm, treaty, anything, whose trigger is impossible to discern, that's not a norm that conforms to the rule of law. Well, if I say that the treaty applies whenever indirect shareholders hold shares in a company, well, the problem with that is that as a state, I cannot know that. So if we look at this case here, well, there is a norm that was contemplated by the parties. That was English law and the contract, right? SPV and the host state. That's the first norm. That's the contemplated norm. Now, there is a norm that is not necessarily known, but it is knowable, which is you know that you've signed BITs as a state. You can check, since the SPV is incorporated in your home state, you can check in the commercial registry who are the shareholders. You get to know their nationality. Okay, so you know that the Canadian BIT as a norm and the Australian BIT as a norm exists. They're knowable. But of course, if there was no SPV, they wouldn't be knowable. Right? But since there is an SPV here, they're knowable. Everything on top of that is not just not known, it's unknowable. So since it is unknowable, how can it be a norm? How am I supposed to let it guide my conduct? Unless, again, we're not actually treating norms as things that are meant to guide conduct. Now, the other reason is you're not meant to, in any legal system, be able, as a party to a legal relationship, to choose the norm that applies to it after the dispute has arisen. That's not a choice you get to make. Every legal system, since Savini, going through even domestic laws, have made it such that you're not meant to be able to choose post-dispute as one unilaterally which of the competing norms apply to you. So in this case, we have 5 competing norms. We have English law, Dutch BIT, Canadian BIT, Australian BIT, sorry, I forgot my own example, and a British BIT, right? 5 competing norms with very different possibilities. So remember the example I gave you. This is a contract specifically negotiated between a country. It's an example loosely based on Occidental Petroleum versus Ecuador. I have no involvement in the case, so I'm free to talk about it. So altering it a bit. There is a specifically negotiated English law clause here. And there is a rather strict clause that tells you terminate if you don't produce oil within 5 years. 5 years, 4 months later, boom, no oil, the state terminates. Now, you may say that's not in good faith. English law knows no good faith. You might say that's not proportional. English law knows no general duty of proportionality. It just asks the question whether you have a right or not, which is why companies, probably in this real example, the SPV would have asked for the English law, not the host state. Now, once the dispute arose, it no longer suits its interest. So what's the solution? Let's check which of the other BITs allows me to add on top of that a duty of proportionality and then use it. And that's exactly what had happened in Oxy versus Ecuador. Right. So in this scenario, how can it be fair for one of the two parties to the relationship, the state and the investor, to get to choose after the dispute arises whether they want to subject themselves to the contemplated norm or to one of the other 4 potentially applicable norms? That has to be something that's sorted out independently of the will of one party and from the start. Well, and especially in situations such as this where there are contracts. I mean, even in system that allows concurrent liability, say between tort and contract, they do not allow that the tort claim exceed the limitation of liability that's in the contract. The next point is ability to multiply chances by multiplying proceedings. So you, as an investor here, get to first choose the norm, right? But in addition to that, on top of that, you also get to multiply the norm if you want. Because one other option you have is, instead of choosing which of these 5 things will work for me, is just initiating all of these and seeing what happens. Right? Now, that has many problems. One is an increased chance of success for one party artificially. As Professor Gaillard has noted in his article that was quoted in the beginning there, that if you have 5 tribunals, that multiplies your chances by 5. Because as a claimant, you need to win once. As a respondent, if you want to prevail, you need to win all 5 times. So it's just an automatic multiplication by the number of the tribunals. How is that fair? How is that possible? Now, the other point is that it circumvents the purpose of an investment tribunal. Andrea said investment treaty arbitration is not a policy insurance. Absolutely, but it gets used as such. And then the third point is that you also get to pick not just on merits, you get to pick the highest possible quantum. So you say all of these tribunals, okay, fine, there will be no double recovery, don't worry about it, I won't collect twice, okay, fine. But this one considered the damage to be $1 billion, this one considered to be 900 million, this one considered to be 1.6 billion. So I'm going to go with that one. And sure, I'm not going to recover 2 of them, I'm just going to cover the one award, just the highest. And then finally, double recovery. Now, double recovery is dealt with by saying, I won't collect twice. But the problem is, in the case I just gave you, what is collect twice? How can you set off 2 awards that are contradictory? If the loss is calculated as 100 by X and as 120 by Y, when I collect 20 under the second award as one of the debtors, the creditors, can anything be set off against the award that have only given 100? Secondly, we don't even deal with double recovery. We just let it be sorted out by national jurisdictions, because we just issue the award and it just goes into the sort of the ether. And then finally, you have, how would you deal with it downstream? Like, I can understand saying, well, if you recovered, whoever is above you can't recover. But if the person that recovered first is shareholder 5, proceeding 4, 3, 2, and 1 cannot be bound by what happened to shareholder 5. So even double recovery doesn't really help. And finally, all of that for what? I've heard 2 reasons. One, because sometimes you're forced to incorporate a local company. Well, sure, incorporate a local company. First of all, that's a choice. But even if it is a forced choice, then the solution is, the obvious solution then would be, give the minority shareholder in that local company the ability to bring a derivative claim on behalf of that company. But then it's on behalf of that company. And then you're not sort of taking the terrain from under everybody else involved, and you're dealing with all of these other problems. The other problem that's usually cited is, what if the state what if the state forces the management of the company out? So essentially precludes the ability of the company to manage itself. What if that's the actual wrong? Well, if that's the actual wrong, again, this is the same reason you allow the shareholders to bring a derivative claim. but you do not, again, allow reflective loss. That's it. Thank you.
Thank you, Mohamed. I think we might change it a little bit, the order, because I think derivative claims, you were going to be more or less in agreement. So I think Andrea couldn't wait to answer what you've just said. So I think we're going to first move that, and then you can answer what Andrea says, and then we may be talking about derivative claim if we have time. That works.
Well, thank you very much, Mohamed, for those thought-provoking observations. It won't surprise you to know that I don't altogether agree with all of them. The first is just, you know, it's you've presented up here. I know it's drawn from life, or at least potentially drawn from life. So it's not that these extremely complicated cases cannot arise, but they are not the norm. So here, one of the factual things is that there is a contract between the special purpose vehicle and the host state with an arbitration clause. That will not always be the case. It's one of the reasons that we have investment treaties to protect investors when they are not able to negotiate a contract, when there is no particular contract that calls for arbitration and calls for neutral dispute settlement in a venue where somebody can get an award that can then be collected upon. I also have to say I disagree with you about the unknowable norms. Those are perfectly knowable norms. The state has chosen to enter into investment treaties. It's entered into investment treaties with particular formulations of the fair and equitable treatment standard, with particular obligations about expropriating, or rather not expropriating, except in accordance with legality criteria, including the payment of prompt, adequate, and effective compensation. So the state knows that. There's no suggestion here that those norms are in any way contradictory. This isn't a situation where you can't comply at the same time with English law and French law. It's entirely possible to satisfy the norms in all of those investment treaties. And indeed, one of the governance mechanisms that one would hope, although perhaps a little bit without a lot of confidence, that states undertake is that when they pass legislation or take other measures, they think about the obligations they have undertaken in treaties and moderate their behavior accordingly. Just to be clear, we are talking about requiring a finding that a state violates international law before any kind of recovery can possibly occur. So it isn't just an insurance policy. It isn't just a claim that leads automatically to recovery. Another thing that I would point out is that remarkably, and something that I think you have glided over, is that this is one of the areas in which investment tribunals are consistent, yet they get criticism even though the decisions are nearly uniform. It's ironic when you think that one of the major criticisms of international investment law is inconsistency, yet here is an area where nearly every tribunal to have considered this matter has come out in the same way. I'm reminded of Emmanuel, who at one stage was giving a talk at Columbia in New York, and he noted that the Argentine cases, where you have this divergence between the interpretation of necessity at customary international law and how it interacts with Article 11 of the United States Argentina Investment Treaty, that Argentina had successfully essentially engaged in a sleight of hand to have everyone focus on this inconsistency in the Argentine cases, thereby taking away attention from the fact that every tribunal to have considered the matter found that Argentina had violated the fair and equitable treatment standard. And so I'm reminded of that a little bit in this context, where you have every tribunal, smart people, some of whom are in this room, smart people who have considered this issue and have come to I think, reasoned conclusions about this matter, and indeed in a remarkable display of consistency in a field that is sometimes riddled with inconsistency. I think some of your criticisms, many of them, assume that a shareholder who recovers reflective loss is diverting that money away from the company and other shareholders and creditors. Yet often that is the only recovery, and the one procedure is the only place that the state will be held accountable. So this leads me to ask, how big is this problem really? One can point to some well-known cases. We all know those cases. But it's hard to think that it's endemic when you think that there have been approximately 1,300 cases, and we still point to the same 4 or 5 cases as the exemplars of the problem. Any regime can have vexatious claimants. Domestic legal systems have these problems as well, but they don't unduly restrict claims. There are prudential limits. Arbitration is costly. So again, another reason why I think we are not so far overrun with claims, and it would be imprudent to throw the baby out with the bathwater, so to speak. Existing doctrines are arguably adequate to take care of the problem. Abusive process, in the event there are multiple vexatious actions, consolidation, both formal and informal. It's always a little bit ironic to think that in the famous Lauder cases, the Czech Republic refused to consolidate. They could have avoided all of these problems, but they refused the consolidation that the claimants were willing to do. Preclusion doctrines could be I think, developed, perhaps in a transnational legal process manner in order to become more effective in this guise. And of course, sometimes limits on recovery that are required by doctrines of causation and actual harm. I also think this is important. It's important to think about the context. Mohamed would have us adopt the rule developed in domestic corporate law, but in the international investment sphere, we're not in a domestic corporate law sphere. We need an international legal framework that is adapted to economic activity in the cross-border setting, where investors need incentive to invest, and protecting shareholder rights help to encourage that activity. Arguably in international law, and in many of these circumstances, perhaps not all, but in many of them, it is the shareholders who are the real parties in interest. Domestic law actually recognizes that the interest of the directors and shareholders can diverge. Domestic legislatures and courts have made a different decision to protect the directors' interests rather than the shareholders' interests. Could it be possible that domestic law has it wrong? Why else do companies maximize benefits for CEOs and executives and not for shareholders? And this arguably, again, contributes to international governance by requiring that states be held accountable for their actions and be held to account for their actions. So, Mohamed, I'll turn it back to you.
Thank you, Andrea. Let me take those in turn. So first of all, how big is the problem? It's not that frequent. Well, a recent OECD report estimates that about 1/3 to 1/4 of all investment treaty arbitrations are for reflective loss. So
3/4 to 2/3 are not.
I think if I have one thing that's causing me a problem out of 10, I'm going to want to deal with it. If the third of something is creating problems, then that's big enough. Now, the second point is that that structure is not actually all that convoluted. For all the reasons you mentioned, and the Dutch and Belgian and all the nice sandwiches that exist for fiscal reasons, this structure is very typical. This structure is now no longer reserved for a multi-billion-dollar concession. It also happens for an investment for a few 100,000, because you can do it for about 10K. So it's no longer even that complicated to run these structures. So that's the sort of the extent of the problem. Now, you also said, well, the norm is absolutely known. But again, back to fundamentals on this one. The European Court of Human Rights have held that for a norm to be known, it needs to be known also in its scope of application, in the set of facts to which it's applied. And I put you back the question, how can any state know the top box or the second one? There is no way, unless one of two things. You either force all companies investing in a state to disclose all of their shareholders and their nationality, which, trust me, that run away that same day, that much rather have no reflective laws than have to say who they are, and everybody above them. Two, you essentially, as a state, then decide that you need to sit down in a perpetual exercise of knowing what it could possibly be the most favorable clause in all of your BITs on every given topic, and that's the one you apply to everybody, which essentially renders MFN useless, and B, it's also impossible because it's subjective. What is most favorable as a clause in a particular situation will not necessarily be in another. So to me, the upper norms are not known. Now, you can always create a mechanism to make it known. This is not an insurmountable problem. You can say a shareholder can claim when they've declared themselves as the controlling shareholder. Sure. But as things stand, it is not knowable. Now, not an insurance policy because you have to prove an international delict first. Well, yes. And if you're in the part of the case law that applies that strictly, sure. But if you're in the part of the case law that says that a simple breach of contract can be a breach of treaty, which that exists as well, I'm not sure that makes much big of a hurdle. Secondly, the consistency point. I actually do not think the case law is as consistent as it appears on this, because the way people have computed reflective loss have allowed for a little bit of difference. Secondly, frankly, consistency over something wrong is not necessarily a merit. So the question is it wrong or is it right? And being consistent and being inconsistent with everyone else for the past 200 years is also a red flag. Finally, it's a solvable problem. You can consolidate. The Czech Republic refused consolidation. You can do all sorts of things through res judicata. One good development in which we can agree is that case law have tried to deal with this problem by different means. Because, for example, the case law starting from RSM, Grenada, going to Apotex, USA, then Ampal, Egypt, then UFGE gas, then Orascom TMT, Algeria. So all of that case law essentially said, okay, fine, since we're not respecting legal personality anyway, you have to actually look at the economic reality. And if you as a shareholder are claiming for reflective loss, you're bound by the defenses available against the SPV since you're claiming through the SPV. So in the words of the Ampal Tribunal, you can't look through the company to get its benefit, but then reprobate the company for the purposes of defenses available against it. So if I'm going to go through the SPV, then I need to have the defenses available against the SPV. But this deals with res judicata. So there would have to have been a first decision in the yellow box for this case law to be engaged. Consolidation only helps with multiple proceedings, but it doesn't deal with all of the other problems. All of these procedural fixes that we can do at best will deal with multiple procedures, but you will recall multiple procedures were my problem number 7. And then finally, on the, I know I already said that, so I'm good.
Well, just one quick rebuttal, if I may. I think your argument about knowing what is in the UK host state bid or the Netherlands host state bid proves too much, because by your argument, if there's never been a claim brought under a treaty, a state can never be held accountable under that treaty because the extent of that state's obligation is unknowable. That's what you're essentially saying.
No, of course not. It's known. I know that
you said the
it
European
applies.
Court of Human Rights says you have to be able to identify the norm in context. If there's never been a case, and if you're setting up a regime where there's almost never going to be a case because there are no claimants, then you're not going to have cases to develop that norm. But I think your argument goes even further to suggest that if we have a treaty with an obligation that's never been spelled out in litigation and arbitration, then somehow the state is off the hook because we don't know what that obligation is.
Of course not. No. Now that's an argument that I have not made. What I have made is that
it's an argument
the existence of the norm has to be known, the substance of the norm have to be known, and then the scope, not precedence on the norm, the scope of application. When does it apply? I need to know that I'm getting into a factual pattern now. I'm going to treat a certain investor. I'm going to treat you, Andrea. I need to know whether I need to apply to you the English law of the contract, the Australian law of the BIT, the Dutch law of that BIT, or the UK law of that BIT. And knowing that, being able to identify that before I treat you is, to me, the very definition of the rule of law. Otherwise, what's the point of this as something to guide my conduct?
But I'm suggesting that honestly, it's the state's obligation to treat you and me the same way without knowing whether we're Egyptian or French or Canadian or American. I think that is the state's obligation, and the state should not be able to avoid its obligations by saying, oh, I didn't actually know you were Canadian, therefore I violated CETA, but I didn't know I was violating CETA, so therefore
So we're merging all of BITs then?
Well, isn't that what MFN could be said to do?
Sorry?
Isn't that what MFN could be said to do anyway?
I would argue wrongly, but even
Well,
then, a good part of BITs do not have MFN.
Right.
And doing that will precisely make it that MFN is unnecessary,
No,
since
but
you have one single big MFN anyway.
Right. Well, first, I think we're conflating two different things about who can claim and then what the obligations are. And I guess I'm relatively comfortable imposing significant obligations on states to act better. I don't want to set up a regime where a state can say, oh, you're an investor from Timbuktu. I don't have to treat Malian investors well because I don't have a bit with Malian investors, but I have a bit with Egypt, therefore I have to treat Egyptian investors well. I would rather have the state err on the side of extra protection and say, well, in case there's an Egyptian investor, I'm going to treat the Egyptian investor as well as possible. And that's part of, I think, the hope of investment treaties is that that there would be, if you will, these kind of indirect governance issues with spillover benefits, not just for foreign investors, but for domestic investors as well. Because if a state is really thinking about how it needs to act in order not to violate its investment treaties, then it should be acting in a way that is I guess, equally respectful of all entities, whether they be domestic or foreign, and depending. Yeah.
I mean, putting aside the fact that these things apply not only to the 5 basic protections, but also to things like currency exchange controls and specific protections that are quite nationality specific. The notion that there essentially needs to be a corpus of law that applies uniformly by all states is well, that would be great if we can agree on what it is. B, go tell the US government they need to extend the same protections that they extend to Canadian companies to Chinese companies. I think they'll refuse to sign whatever treaty tells them that pretty quickly. Go tell the Europeans that they have to treat, say France has to treat also Chinese companies the same way it treats German companies. The ability to discern and indeed discriminate is part and parcel of our investment treaty system. That's why the treaties are different. And treating them all the same, it's not just a question of procedural entrance to a uniform law. If that were the case, our problems would be much simpler. Our problem is that we have different laws. If these were all one norm and we're disagreeing over access to arbitration, we'd have a much more discrete debate. The problem is we're disagreeing over 5 norms, and in practice, some of them are contradictory. Taking the basic almost always example, the English law of the contract will be contradictory with most treaties because it is strict, whereas they are more continental. It has no good faith, they have good faith. It has no force majeure, they have force majeure. It knows no hardship, they know hardship. So, and given that that's not an unusual situation, English law being in like 60% of energy contracts globally, that is quite a big problem.
So I think I want to, I might not have the last word. I let Mohamed say something else if he chooses, but I thought I would attempt to close on the idea that perhaps we're in agreement that it would really be ideal if we go back to the drawing board to have a multilateral agreement on investment so that we do have uniform standards applicable to everyone and where people have perhaps a better idea what they're signing on to.
If you and I get to draft it, happy to.
I just want to remind people that if you need to leave before the boat leaves for the cruise, it's within 5 to 10 minutes because the captain told me they're actually leaving at 8:15. So maybe now let's open to the floor and see if we have any questions, any reactions, any contradiction to some of our debater. Yeah.
Have a question, because one thing I didn't hear during this discussion was a discussion of how damages are calculated. And I think you can make an intellectual argument that direct costs direct damages and reflective damages can actually be considered to be equal. But going to Mohamed's comment about, creditors, employees, future damages not being taken into account in reflective calculations, does the state actually put aside amounts for the employees, for the creditors, for contingent liabilities? And if they did so, then that might be a strong factor in arguing for reduced reflective damages. Anyhow, I'll stop there.
Maybe I started taking that one? Sure. So, okay, the two prongs. How damages can be calculated in reflective loss. That's precisely the problem. There is a recent UK Supreme Court decision from 2020 called Merrick's, whose reading I would very much recommend to you. The court is divided in two, the majority of which reconfirmed and explained in a very nice way the rule against reflective loss, and the dissent, which dissented that it should be a rule of law, but essentially agreed that it's a rule of fact. But it comes to the same thing. And one interesting thing they say about quantum is that one of the problems of trying to compute reflective loss is quantum. Because normally, unless you disregard separate legal personality, which, again, one cannot and should not, except if you have expropriation of the actual entity, the company, this one, suffers a loss because this contract is terminated, right? This company, the moment it suffers a loss, it gets a claim, right? That claim becomes part of its whole assets. And what both majority and dissent in the Supreme Court decision found was that you need to compete. If we would allow, so they were reasoning in the alternative, if we were to allow reflective loss, then we would need to account as sort of in the actual scenario for the value of the claim that the company has acquired. I know of no tribunal that has done that. None. But I don't know of anybody who's argued either, so it's not the tribunal's problem, it's also council's problem. But so no, I'd very much disagree that it is simple to calculate that difference. In fact,
I didn't say it was simple, but I think it can be argued.
Yeah, I mean, there are certain situations in which a shareholder will suffer a loss independent from the company. Those situations, if they can be proven, obviously should be remedied. But it needs to be independent from the company. I think the test for it was in a 2003 or something. Anyway, the easiest formulation for it is if the loss will be franked, if the loss will be compensated, should the company get the money, then the loss is reflective, it's not independent.
Do we have other questions? No? No? Okay, well, thank you very much to the both of you. It was really heated at the end, and not only because of the debate, because of the sun. But thank you very much. Thank you again for Gaillard, Banifatemi, Shelbaya for organizing that. And, well, now let's enjoy the cocktail. Thank you very much.